600 or better. And then the physical inspection of the ballot based upon your training, education, experience, analysis would be necessary.
Well, think of it this way. And I work with the Federal Bureau of Printing and Engraving, when I was at the Paper Institute. I helped to design some of our currency. And there's polymer threads in there, there's different inks, there's a hologram. You can't take a scan of a dollar. When you go to Kroger or Publix and they pull out the ink, the material that they wipe across the bill to check to see if it's authentic, they couldn't do that on a scan. You have to have the actual document.
Thank you.
Just a couple of quick questions to follow up. The first is, we're looking at over 145,000 distinct physical ballots. And I'm trying to get a sense for what's helpful in order to resolve the issues that we have in the case versus what's academically interesting. And I'm also thinking a little bit about process in terms of the speed of the process and the completeness of the process. Deriving the necessary information from the process in order to determine the issues in the case. Infrared is something you described. Ultraviolet, I believe is what you said. Probably a difference, I'm sure that there is, and I apologize for that. Is there a table device that something can be held up to that would allow an expert to see what they need to see on a piece of paper, but using the ultraviolet analysis?
Ultraviolet, you could put it in a box, and you could shine light on it, you could see the color change.
So,
but that's going to be a piece by piece manipulation.
I'm sorry. Here's a process question. Okay. Let's assume that this is a ballot taken out of the box. We flip it over. You get a chance to look at it from a distance of 3 feet. In order to determine its paper stock, what would have to be done in that environment? Would you hold it up to the light? Would you have to touch it? What would you have to do to determine the paper stock?
Paper stock to determine it?
To determine the, not necessarily the materials used, but maybe the thickness, the difference in the thickness, for example. That's one item. Right? The other is actually the difference in materials, I guess, as between ballots. True?
Mm-hmm. Yes. So
those are two things that you could be looking at. And how would you look at those two things in this environment?
In this environment, thicknesses, you could potentially use calipers for thickness. You could also do a 5-place balance for weight. But there's a problem before we get into all these details. I don't even know what the ballots look like. And paper absorbs moisture. I don't know how they've been stored, if they've been wrapped in plastic. It won't change the actual ink on the paper, but it will change work, so to speak, the document. So that might change a little bit how we would have to approach testing.
So you're saying that you can't really advise the court on a protocol for determining those things until you actually see the ballots.
Exactly. Anytime I set out to do an experiment, the first part of that is working with the customer, taking a look at the problem. The first one's always the most difficult, perhaps, to set up, and then things get very quick after that. But that's scientific protocol.
That sounds right to me. I mean, in terms of the way of approaching this issue, if in fact we go in the direction of unsealing. Okay, let's see. Any other questions for him?
No, sir.
Just one last question, Dr. Dadoskin. Is the way in which you describe your approach, does that comport with generally accepted scientific principles and methodologies?
Yes, it follows good forensic scientific principles and good laboratory practices.
All right, that's all I have.
Okay, Ms. Ringer?
Yes. Good morning, Dr. Is Dieter Hoskin?
That's close enough.
Okay,
Yes,
I'm
they
sorry.
are. That's
Dieter
fine.
Hoskin. Okay, I'm sorry. I wrote down how I thought it was spelled. You said you were present for Mr. Jones's deposition. Is that correct?
I was not. I read over some of his stuff. I was not present. I read over
Okay.
some of his.
Okay. Were you also given Mr. Jones's affidavit that has been entered and filed in this case?
No,
You were not. Were you aware that okay, let me see. Would your analysis be impacted by the fact that there are valid absentee ballots that would not be folded?
no, that was the fold is only one part of my investigation.
I understand, but would your analysis be impacted by the fact that there are, in fact, could be valid non-counterfeit ballots that would not be folded? They would be valid, but they would not have a fold. Would that impact your analysis?
Not at all.
Okay. Were you made aware that there could possibly be valid, that there will be valid ballots that will not be folded?
Yes.
Okay.
I was aware of that.
I want to make sure I heard you. Did you say that you would be looking for the date stamp on the ballots?
No, on the envelopes, it was my understanding that they run through the Pitney Bowes machine and
Yes.
and
Okay,
printed.
I misunderstood you. Thank you, because I wrote that down. And so, as I understand, and you've told Your Honor that you can't say specifically at this point, but you're saying that you need to be able to physically touch each 145,000 absentee ballot, as well as have a scanned 600 DPI image of each. Is that correct?
I believe we start with this, we do have to rescan all of the ballots at 600 DPI.
Mhm.
The first step of my forensic analysis is to look at the ovals for concentricity, size, shape, with completeness of fill. At the same time, I would like to illuminate them with ultraviolet light. If at all possible, I would like to go ahead and also illuminate portions of them with infrared light. But until I start to actually look at the ballots, I'm not quite sure what I'm even starting with.
No further questions, Your Honor.
But it doesn't sound like the illumination requires that you touch them. Somebody else could touch them. Somebody who works for the clerk's office, for example, could be the one who's actually manipulating at your direction the ballot so that you have what you need.
Yes,
It's the
ultraviolet would be easy. Infrared's going to take an analytical chemist.
Okay. But in both scenarios, are you saying that someone who is an employee of the clerk's office could hold and manipulate the ballot themselves in order to get you what you need?
Potentially, yes.
Okay, because I have.
Thank you for that clarification.
You're welcome.
All right, let's see. Anything else, Ms. Ringer?
No, Your Honor.
Ms. Vadaswara?
No, Your Honor.
Thank you. I think in the back.
No questions, Your Honor.
Thank you, ma'am. All right, and if there's nothing else, then perhaps this witness can step down.
I just have probably a couple of follow-up questions.
All right.
Just so the record is clear, Ms. Dederhausen, or Dr. Dederhausen, what is the object of your need to study the oval and the contents, the ink, and the way in which it's placed on the ballot in the oval or on the oval?
The goal of my work in this project is to determine whether or not these ballots were printed by a machine, filled in, the ovals were filled in by a machine, or if they were filled out by a human. And if they were filled out by a human, how many times did that human fill out ballots? And based on forensic image analysis, we can do trends very accurately to be able to determine that.
And can you do that with a high degree of confidence?
I'm sorry.
Can you do that with a high degree of confidence if you have the ballots scanned at 800 DPI or 600 DPI?
Yes, I'd like to work with very high accuracy.
Thank you, that's all I have.
Okay, so your work would have to start with the scanned images, and you could determine after that whether or not you need access to the physical ballots. Is that true?
That's correct.
Okay, thank you.
John, I have no further witnesses.
All right, thank you, ma'am. You can step down if there's no further questions.
Thank you very much.
None.
All right, appreciate your time. All right, any witnesses from your side, Mr. Harding?
I have one, Your Honor, he's actually online, we might have to let him in.
Who is he? And
Mr. Pulitzer, Jovan Pulitzer.
and tell me the nature and scope of his testimony.
It's gonna be quite similar to the testimony you just heard about the 600 DPI. As far as why he needs 600 DPI or higher to run the images through his software
Do
technology.
you think it's cumulative?
Excuse
Do
me?
you think it's cumulative?
I think he's gonna say pretty much what she said, that he needs 600 DPI or better.
Because I don't,
DPI.
if that's something that you are in agreement with them, then I'm not sure that it's helpful to us.
Yes, sir.
All right, thank you. Anything else? From Ms. Ringer or from Ms. Batswara?
No, Your Honor.
No, Your Honor.
Okay. Let me just make a couple of quick comments, which might direct the closing argument connected with this motion to unseal. I do think, based on what I've heard, that reproducing the absentee ballots at 600 DPI is appropriate. So the question that I have really is whether instructing the county to do that, requiring the petitioners to pay, is sufficient. That seems like the most straightforward initial first step. And Ms. Ringer and Ms. Vadaswaran, I guess what I'm wondering is that something that is possible? Do you need to consult with your clients and report back, or do we have to go in some other direction? And if you don't think it's an appropriate disposition at this time, then I'd like to hear that too. So why don't we back up now that you've heard what I've said, and we'll start at the beginning, and we'll ask you, Mr. Chile, to make any kind of closing you'd like to make.
Thank you, Your Honor. On behalf of Petitioner Caroline Jeffords and Robin Sophia, we want to thank the court for giving such thoughtful consideration to this matter. It is a matter of very important to my petitioners and also to everyone that voted in Georgia. Because everyone needs to know that there was transparency by government officials in the way in which these votes were considered, the absentee ballots, and the way in which they were tabulated. We have, through the testimony that the court has heard today, through Mr. Sawyer, we have pointed out that there are gaping holes in the total batches that were part of the risk limiting audit, as compared to the total batches that were in the scanned ballot images that were part of the election night scanning at State Farm Arena into the 5 scanners, resulting in a 21% error rate, which is very troubling on its face. We therefore have respectfully requested of this court to permit us to have access to the actual paper, the envelopes, and the paper absentee ballots for scanning purposes to begin with.
When you talk about the envelopes, is this something you've requested and through that, I guess it's the RPD number 10?
Yes, Your Honor.
And is there, is it this, the county's contention that the envelopes are also part of the sealing? Or is this a document or set of documents that are separate and apart from that, that can be produced through regular discovery?
No, Your Honor, you're correct. The documents are also under, the envelopes are also under seal.
Okay, and so they would be located in the same place?
Yes, Your
And
Honor.
is there any personal identifying information on these envelopes?
Not that's readable to the human eye. I believe there's a barcode that distinguishes a precinct and address of the elector, but it's not readable to the human eye.
I think it's the total number of envelopes that's the issue, not anything else. And so I'm wondering also whether or not it's possible to produce the envelopes in a way that does 100% eliminate any personal identifying information. So that's something I'm going to need some feedback on. In other words, if they were allowed to inspect them or to receive a 600 DPI copy of them, would that in any way reveal any personal identifying information? And I'm seeing that the Attorney General attorney is standing, and I think that I'd like to defer to her at this moment just to get some additional input, if that's all right.
That's fine, Your Honor.
Go ahead.
Yeah, Your Honor, thank you for letting me speak. The envelopes that we're talking about, the outer envelopes, absentee ballots, that would include a voter's name, address, as well as signature. And the Secretary of State's office does consider that personally identifiable information that would make someone subject to possible identity fraud. I don't think people want their signatures out there, so.
There's no way that I'm going to allow for that to occur.
Thank you.
All right, the only question is what is it that we can get that would be sufficient? I mean, for instance, the number of envelopes, can they be counted? You just need a tabulation of the number of envelopes. Isn't that what I'm hearing, Mr. Chile? You just need the number of envelopes?
Yes, we could go with a scan of just the front of the envelope, which only shows the address for Fulton County, where the envelope is to be mailed. It wouldn't show signature, which is on the back of the envelope.
You just want the front.
Right.
Is there a way that just the front of the envelopes can be produced? And if they are produced, would they reveal any personal identifying information? Or do you need to think about it?
Well, we would object to the envelopes being produced entirely, and I can get to that if, when I get to my argument portion, but I would have to defer to Fulton County if they, could produce just a scan of the front copy, or the front page of the envelope. 600
DPI of the front and nothing of the back. I'm wondering if that creates an issue. So let's find out from, as you move along here, okay?
And Your Honor, if I haven't seen the envelope, so I don't know where this time and date stamp is on the envelope. I don't know if it's on the front or on the back. And if Mr. Jones was in his testimony was kind of at places contradicting himself as to where it was, whether it was on the front or the back.
Mi-
But
Mr.
sure,
Cheeley, Mr.
I'm sure that we could, if it is on the back where a person may have signed of their oath that this is their vote, then we can redact the signatures of that person.
Well, anyway, that sounds like a process. Let me see, is there, we're gonna come back to this issue about the envelopes. Is there anything else, Mr. Cheeley, that you're asking the board to do?
John, the other component would be that we would like, when the scanning, is being done, we would like to have people there to, look at the paper ballots themselves, because just from physical viewing, you can tell whether or not, the ballots have been trifled. Because they'll have the two camel humps. And we'd just like to have somebody there, and, they can be, if they touch it, they can be wearing latex gloves, so they don't anyway, put any oils from their fingers on the ballots.
I'm not inclined to let them touch it. Let's go on and see what else we have. Mr. Hardy.
Judge, talking with our, been communicating with us, he's concerned about the county doing it, because there's some chain of custody things he has to do with regard to his software and calibrations that have to be done with the scanning. So he's concerned about the county go to bulk scan versus the way he would need it for his software. He's available to tell you about that if you need to hear that from him.
And you're,
1 second. Is there anything else? Mr.
Yes, and there's some human factors that he could talk about that may create problems with bulk scanning. We'd ask to be allowed to scan them and itemize them the way we need to for his software.
Well, all right, Ms. Ringer.
yes, Your Honor, there is a chain of custody issue under 52 USC sections 20701. State and local officials are required to maintain for 22 months after the conduct of an election all federal records and papers for elections. And so we must abide by the federal law. We submit that Your Honor is right in that any handling of the documents must be done by Fulton County election staff and or clerk staff. If they want Mr. Sawyer or someone else to be present while that occurs, that's fine, but the documents must remain in the control of Fulton County staff.
Okay, tell me more about the other pieces of this now. You hear what they're asking for in terms of 600 DPI, a scanning of the ballots, and also the front of the envelopes at this point.
So I'm not clear on the envelopes, Your Honor. I think if the plaintiff were to provide us with the scanner, we could in fact scan the documents at the 600 DPI. We've had a little.
The court has a scanner, a 600 DPI scanner. I was talking to our technology staff just a moment ago, and we would be happy to provide one just so that there's no issue about the scanner.
Okay. With respect, I'm sorry, with respect to the envelopes, I think we need a little bit more clarification, Your Honor. So there are two envelopes. I'm assuming they're talking about what would be the envelope that the elector sends the absentee ballot back in, either the yellow envelope or the yellow and white envelope. And I'm seeking clarification from my client as to whether or not there's any identifiable information on the front of that envelope. The back of the envelope does have the oath, does have the signature, and that the signature is the signing of the oath. And that is where Mr. Jones testified that the time and date stamp was provided. He
So it's on
specifically
the back.
spoke about the time and date stamp being on the flap opposite the oath, because they never want to cover the oath and thereby possibly cover the signature. So I just want to get clarification as to what is on the front of the envelope.
I see. So you won't have a time and date stamp on the,
It
On
will
the
not
other
be
side.
on the front, it will be on the back.
well, that might just be a limitation on what we can do, unless there's another workaround. But the number, I'd like you to think about this issue. This is something that's just really come to light today. And it requires perhaps a little bit of reflection. So understand what the goal is, and come to me with some solutions, if you could please. And in that regard, is there anything else, Ms. Ringer?
No, Your Honor, that's all. I am seeking to get some more clarification before we end today. I'm working on that right now.
Thank you. Ms. Vatswaran, is there anything you'd like to add by way of closing?
No, Your Honor.
Okay, and let's go ahead and hear from the Attorney General's office.
Thank you, Your Honor. Where would you like me?
Anywhere you're comfortable. If I could come up here, I think everyone would like to see you, so why don't we just put this on landscape view and make sure that you are here and available for all. There you go. There you are, right there. And you don't have to, you can address me if you'd like, you can be sideways if you'd like. It's something that's just as important that the people online see you as that I see you. So just give us a little bit of an angle, okay? Perfect. Thank you.
Well, thank you, Your Honor, and I appreciate being heard, and I appreciate the thoughtfulness that the court is giving to this issue. The Secretary of State maintains his position that was set forth in our amicus brief that there's really no basis under state law for the petitioners to obtain the sort of citizen audit that they are seeking in this case. The Elections Code provides for ways to explore and examine the types of allegations that the petitioners are making, and those have already been done under the Elections Code. These ballots have been audited. They have been recounted. They have been certified by the Secretary of State as well as the governor. The election was, where are we, like 8 or 9 months now away from the election. The Elections Code also provides a way for any aggrieved voter to challenge the results of an election through an election contest. That is not what the petitioners did. Many petitioners did file such election contests, and they have all been dismissed.
It started and then it shifted. It started as an election contest and then shifted. At least that's what I was told when it came to me. I'll have to go back and review the file. Ms. Ringer, if that's incorrect, let me know. Anyone is suggesting that this didn't start that way, let me know.
I would say that I think it's never been an election contest, Your Honor.
All right, well, I would have to go back and review the pleading, especially the first complaint, not the amended complaint, to see if that was the case. But in any event, it's changed. Go ahead. Now it's essentially a set of claims related to violations of their individual constitutional rights under the state constitution.
I understand that, Your Honor, but again, the Elections Code provides ways for aggrieved voters to bring those types of grievances before the court. If they want to make allegations that illegal votes were cast, they do that in the form of an elections contest. I understand that there are constitutional claims that are raised here, and that the court may be viewing this as sort of a typical discovery dispute, but we're not talking about typical discovery documents, and I know the court understands that, and you understand that it's important to maintain the security and integrity of the ballots, and I appreciate that fact. And so the Secretary of State wants to offer, if the court is inclined to grant some sort of limited audit or inspection, wants to suggest 2 limitations to the court as to how that should be done. The first thing is that the ballot should not leave the custody and control of elections officials, and it sounds like that is what the court is considering, and we appreciate that. There are 2 reasons for that. First, it's under state law, these ballots must be maintained under the custody and control of elections officials, and also under federal law. This issue has arisen recently in an audit that's being conducted out in Arizona, where the Department of Justice sent a letter to the president of the Arizona State Senate and informed the president of the Senate that the Department of Justice is taking the position that by releasing ballots outside the custody and control of elections officials, then it violates the Federal Civil Rights Act. And I can provide the court with that
I think that's right.
citation. It's 52 USC section 20701. And so that would also be our concern in this case. The second limitation that the Secretary of State would like to suggest is that if an audit is going to be conducted, that it be truly independent. And that either independent auditors conduct it, someone selected by the court or agreed upon by the parties, but that it be done in a truly independent way rather than conducted by the petitioners in a way that might be done with some preconceived biases. So we believe that those would provide reasonable limitations on the scope of the audit that would balance between transparency and also respecting the integrity and security of the ballots.
Okay, I'm intrigued by your last set of comments related to an independent auditor. I take it that the petitioners would be of the view that they are the ones to defend their own constitutional rights in this suit that they have filed. What would be your response to that? Your response is essentially that there are other ways that they could have done it. And because they exist, this is not a way that should be permitted.
That is correct, Your Honor. I just believe since this was not done as a proper election contest, in order to maintain the security and integrity of ballots, if we're going to be turning over secure ballots to outside experts, those should be independent auditors.
I have no inclination at all to release these ballots to anyone other than the clerk in the county. I don't know how else I can say that. But whether they have the right to conduct these independent viewings, maybe not a physical inspection, but an inspection nonetheless, a visual inspection, combined with an opportunity to have ballot images at a resolution that allows them to pursue their claims. Well, that seems to be something that they have the authority and the right to do. I have never seen in this case a motion to dismiss from anyone for any reason. And in the absence of considering things in that way, then this does take the form of a civil case where there is some discovery under the declaratory judgment, arguably. And so if I'm thinking about that incorrectly, I would also appreciate some additional feedback.
Well, it is possible that Fulton County or the clerk's office may want to retain their own experts, and if the court would also indulge the secretary being able to have his investigators present for any proceedings that occur where the court does allow access to the ballots.
I would welcome the secretary of, I would welcome your involvement and their involvement, and also the those types of reasonable requests would be honored. And we just have to figure out exactly how to do it. Thank you.
Thank you, Your Honor.
Your Honor, I did have one that I wanted to clarify.
Okay.
On this 600 DPI, and the 600 DPI scanned resolutions, they have to be formulated in an uncompressed file. Most scanners only do it in a compressed file. Dr. Detter Hoskins has to have it in an uncompressed file, and she can confirm that while she's still here. Dr. Detter Hoskins, would you step back up?
Well, wait. I control the evidence in the case, so you don't call a witness.
Okay,
Um,
but that's why just any old 600 DPI scanner from, Office Depot won't work, because not all of them are set up to do uncompressed files.
Okay, well, that helps a lot. Why don't you go ahead and just submit in pleading form as part of the record, just exactly what form this 600 DPI scan would have to take. We'll give Mr. Chile and his clients the opportunity to submit something like that. We'll also give Mr. Harding an opportunity to submit something similar. And then we'll make a decision as to, we'll see whether or not we have a conflict between the formats being requested, and that might require another discussion. I mean, in that regard, that might require some additional expense, which the plaintiffs would have to absorb if the scanner that the court has is not sufficient to do that job. And I think that we're going to need to have another meeting to talk about protocols. And so that's kind of where we are. But thank you for that. I do appreciate that information. That's very helpful.
And there are third-party vendors that will come on site and bring their scanners and do that, the scanning uncompressed.
I'm really not comfortable with third-party vendors. I think that, the acquiring of an appropriate scanning machine by the court or by Fulton County or the clerk's office is probably the better way to go. Let's get a sense for whether or not that's cost prohibitive. Let's see where that I'm not exactly sure how to resolve and work through that issue yet, because I don't have the information, nor do I have the technical background to properly evaluate it. I'm going to have to reach out to our technical people here. I will tell you that what I'm likely to do, with your permission, with everybody's permission, is to have our chief of technology take a look at the requests that are submitted in terms of 600 DPI scanning formats that are needed, and then use that person as a consult to the court to help evaluate the road forward in terms of the right way to scan these, so that you both have something that you can use in order to investigate your claims, have discovery in relation to your claims, and to cost that out. Understand that we would expect that the plaintiffs would be the ones who would bear the burden of this discovery. And so that's typical. If you want it, you pay for it.
We're prepared to do that, Your
And
Honor.
you're prepared to do that. And so we're going to have a conversation. I'm going to, Ms. Ringer has some additional questions or thoughts, and we want to hear them all.
Thank you, Your Honor. I wasn't sure if you were finished. It just came to mind when you spoke about the plaintiffs bearing the cost. There would be some cost for the staff that would provide the scanning, the actual labor, and we would want that to be considered in the court's evaluation as well.
Well, that's right. I understand that and respect that, and I think that would be part of the costs of the case.
May I address the court quickly?
Well, let me just tell you what I'm going to do. I'm going to grant the motion to unseal the November 3rd, 2020 general election absentee ballots that are sealed pursuant to 21-2-500A. To the extent that the petitioners are requesting that they be permitted to inspect and scan those ballots. But the petitioners will only be permitted to inspect and scan the ballots in accordance with protocols and practices that will be set forth by further order of the court. And so what I'm going to do is have the parties appear at the location where the ballots are being stored at 10 a.m. on May the 28th, which is next Friday at 10 a.m. So again, the motion to unseal is granted to the extent petitioners request that they are permitted to inspect and scan the November 3rd, 2020 general election absentee ballots that are sealed pursuant to OCGA 21-2-500A. And I want to be sure that everybody understands that. I know that this is repeating myself, but I think it's important to do that since we have so many people who have to digest the information. And so it is, so the petitioners, again, shall only be permitted to inspect and scan the ballots in accordance with protocols and practices that will be set forth by further order of the court. And counsel for the parties are the only ones that shall appear at the location where the ballots are being stored. Counsel for the parties. And we might have to make an additional addendum there to include an expert or two. And so what I'm going to do is I'm going to ask that you submit to me the names of folks who, like, for instance, the materials expert that we heard from today, who might also be permitted to join us. I'm inclined to not have a WebEx meeting at that time, but instead to memorialize it by way of videotape and perhaps have a court reporter present. But it wouldn't really strictly be a court hearing. It would be more discovery related. And so the same constitutional requirements for an open courthouse would apply under those circumstances. But what we would do is we'd just have an organizational meeting, for lack of a better way to put it, that again would be memorialized and available to be made a part of the record as we move forward. Okay? Any strong objection to that?
No, sir, Your Honor.
No.
All right.
No objection, Your Honor, but point of clarification, please.
Yes.
Between now and next Friday, would you be entertaining or do you need the parties to speak with respect to a protective order? Would that be part of the order that Your Honor is going to put in place with the protocol?
Yes, as we discussed, I believe it was at the very first hearing, as it relates to the motion to unseal, a protective order, a special master order, and a and also some conferring as between the parties as to what experts we absolutely must have present at the organizational meeting.
Thank you, Your Honor.
It's one of those too many cooks can spoil the soup. So, you know, we're just looking at making sure that we have just who's absolutely essential at the organizational meeting. And I think that what I would like, I don't think that I believe that the two witnesses that we heard from today would be appropriate people to have there. And perhaps a similar expert from your side.
Yes, sir.
Just one, because I think you only had one be present. And I'm trying to decide if we have to have them there in person or if we could call them in after we've kind of gotten started. This could be a phase 2 approach. We could start at 9 o'clock with just counsel. We could confer about the basic elements of the process, and we could pull some experts in as needed in order to address certain pieces of the development of the process. Okay, so you have those experts sort of on call and available, maybe in the parking lot, and then we can kind of bring them in as needed in order to help us design a good process. Any other questions?
Your Honor, would the court permit a representative from the Secretary of State's office to present this organization?
Yes, ma'am. If you'll just give us the name of the person.
Yes, I'd be happy to do that.
All right, and and I wanted to just say how much I appreciate the civility of the group so far in working through these difficult issues. I think that you've really been mission focused and respectful toward each other, and I think that this is an example that we need to see as we continue to move forward. So again, thank you for your professionalism, thank you for your time. I think that this is a good starting point. We'll see everybody at 10 a.m. on May the 28th at the location where the ballots are being stored.
Thank you, Your Honor.
And we're recessed.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome. I'm sorry? Is there a question? We're okay?
Awesome. So that was a court hearing happening here in Georgia to unseal the Fulton County ballots. If you missed any of that video, please go back and watch it from the beginning. I got on a little bit late on it. When I got on, there was a witness giving the testimony about the reason for needing to scan the ballots at 600 DPI. The judge has granted that unsealing. That is going to happen next Friday, the 28th, at the location that the ballots are currently held. The attorneys and some expert witnesses will be allowed to go and physically inspect the ballots at that location. The court is going to figure out how to scan the ballots at the appropriate DPI, at 600 DPI uncompressed, and then at that point provide those to the plaintiff in this case. And at that point, I'm sure Jovan Hutton Pulitzer will be involved with analyzing those scanned images at the appropriate DPI. So if you like the video here, please give a comment, like, subscribe, all that stuff. Let's so this was kind of a impromptu live stream here, so I just kind of that hearing was going on, and I jumped in here and got that live streaming on the channel here. So we'll see you guys on the next one.